ready? Okay. All right, then we'll call the meeting to order, and we'll begin with the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. Good morning, everyone. The first item we have on the agenda for this morning is the approval of the minutes from our last meeting on June 6, 2025. They were circulated to the three board members, and unless anyone has any changes or additions they wish to make, we'll entertain a motion to approve the minutes as submitted. Commissioner Gahn? Second. By Commissioner Schermack. All in favor? Aye. Aye. Opposed? Okay, then those minutes will be adopted. The next item on our agenda is the opportunity for the public to address the board on agenda items only. So first we'll hear.
Joan Hodawana, Scranton. With regard to the motion to declare a special election for the next commissioner, for the sake of argument, let's assume that that motion gets approved. I have some questions with regard to the timeline that would follow. If it's approved, when would the public know whose names are going to be on the ballot for that position?
Yeah.
Joan, the deadline for them to file their paperwork would be September 15th.
But when would the public know who's actually going to be on the ballot?
We can give updates daily as to who files the paperwork. It would be up to the parties to submit their candidate, the two major political parties, the Democratic Party and the Republican Party. Again, that deadline is the 15th of September.
I understand that.
Okay.
Does the election board have to meet to approve the ballot itself?
They do not. We go over the ballot proofs once we have all the candidates.
So sometime in September, we should know who's on the ballot.
You will know. You can contact
Okay.
our office at the close of business that day.
All right.
You know.
So the election would be on November 4th, okay? Do we then have to wait a certain amount of time before the election is certified, and how long would that be?
You mean after the vote?
After the vote. You have to give your imprimatur on the names.
Well, the special election will appear on the November 4th ballot.
I know that, but
Right.
do they have to be certified before they can say this is the actual person that won the election?
Correct. Anybody
Yes,
who's
I mean,
elected.
that would
When
be
is
for
that?
all the positions that will appear on the ballot.
When does that certification occur?
There's different things that come into play with that. There's no specific date because people could challenge things. There could be recounts.
Okay.
So sometime after the November election.
Okay, so my understanding is that your first county commissioners meeting in November would be Wednesday, November 5th? That's right. Okay, and the second one will be Wednesday, November 19th. Yes. Here's my point, or my concern. It would probably be no earlier than sometime in November that a potential winner for that seat would be sworn in. And by that time, most of the working sessions on the budget have already transpired. Would you consider the possibility of, once you know who's running, should we have such an election, allowing them to be bystanders at any future budgetary meeting so that they don't go into a vote on the budget dumb and happy? I would like to see.
You're asking the wrong person in terms of what they'll.
I think if we were be realistic here, there may be 20 people on the ballot. I would say that after November 4th, whoever the winner, the potential winner would be prior to certification. I don't think it's up to the two commissioners. You can have that person come in and sit down.
We'll take that into consideration.
Please do.
Well, there's also a possibility that whatever happens today, that the courts will appoint us a temporary commissioner. Is that what could possibly happen? I'm not sure on that.
They could do that, because it'd be only for like 2 months.
I know, but
If they're gonna appoint someone to that, and then 2 months later, someone else is elected, and they've done certain things over that 2-month period,
Yeah.
you know, it would be null and void. I
Well-
think the courts would take that in consideration.
Well, we'll see, because we could end up with 4 commissioners, because then there'll be a lawsuit on who's really the commissioner, so this will be interesting.
Anyone else in terms of any public comment on any of the agenda items? Anyone else wish to speak?
So Paul Walker on behalf of the Lackawanna County Democratic Committee. So thank you, Chair and members of the Lackawanna County Board of Elections, for the opportunity to address you today on behalf of the Lackawanna County Democratic Committee. My client wishes to go on the record here today as making a formal objection to the proposed election, the special election to fill the vacancy and have an election for a new commissioner in November. The Lackawanna County Democratic Committee supports, obviously, free and fair elections, supports democracy, but believes in the rule of law, and this election is not allowed under the applicable law. My client respectfully submits that the Democrats won the seat in question with Commissioner Matt McGloin and is now entitled to the process under the Home Rule Charter for an appointment to fill his vacancy, a process that is underway and we hope will happen speedily once the Supreme Court, Pennsylvania Supreme Court, ends Commissioner McGloin's appeal. With that in mind, I would like to outline a few simple but key concerns regarding the proposal before you to place a special election for this vacancy on the November 2025 ballot. First, this action is premature. Under Section 1.2206 of the Home Rule Charter, one cannot proceed to subsection C for a special election without first completing subsection B, which governs the interim appointment. As affirmed by the Commonwealth Court in its July 18, 2025 opinion in re appointment to fill a vacancy in the office of County Commissioner, the Home Rule Charter's procedures must be followed sequentially, and that appointment process, drawing from the Democratic Committee's submitted list, has not yet been completed, despite the Supreme Court's denial of Commissioner Gaughan's emergency petition on August 15, 2025. The charter, the Home Rule Charter, also makes clear that in order to do a special election, it has to be according to the laws of the Commonwealth of Pennsylvania. In this case, the laws of the Commonwealth of Pennsylvania actually do not set, there is no provision to have a special election that a commissioner serves out the term, and that this was decided in 2000 in Ray District Attorney. Second, this decision is not within the purview of the Board of Elections to make. Proceeding would be acting ultra vires or beyond legal authority. The powers and duties of the board, as enumerated in 25 PS Section 2642, includes 16 specific responsibilities, such as preparing the ballots and certifying results, but do not grant the unilateral power.
Go ahead, finish up.
Thank you. Do not grant the unilateral power to declare or schedule a special election. In prior instances, such as the 2019 mayoral vacancy, it was in Scranton, it was City Council that issued the writ of election. For state legislative vacancies, the presiding officer of the chamber issues the writ. Well, 25 PS Section 2776 at SEC does not specify for county commissioners. The Board of Elections' role is to execute the writ once issued by the proper body, not to initiate it. In this case, that authority would rest with the county commissioners. Third, we respectfully submit that the members of this board consider whether potential conflicts of interest warrant recusal. Under 25 PS Section 2641C, recusal is required in situations like personal candidacy or charter-related ballot questions. Given that this decision affects majority control and the duration of an appointee's service, impartiality concerns arise for Commissioners Gaughan, Shermack, and Judge Nealon as a judicial member. All three impaneled members present could have personal reasons for steering this outcome and that perception of partiality warrants deep consideration. Finally, we must acknowledge the political context surrounding this proposal. We would not be here today if Commissioner Gahn had prevailed in his recent court challenges. It is worth noting the inconsistency prior to recent rulings. The position was that state law governed over the charter. Now the argument has shifted to prioritizing the charter. This reversal, coming on the heels of the Commonwealth Court's affirmation of the Home Rule Charter and the Supreme Court's denial of Commissioner Gahn's petition on August 15th, 2025, raises questions about the motivations at play and personal conflicts of interest. In conclusion, the Lackawanna County Democratic Committee urges the board to refrain from placing this matter on the ballot. Doing so would respect the established legal processes, avoid unnecessary conflict, avoid unnecessary costly future litigation, and uphold the integrity of our county's governance.
Can I just, only because obviously 27 years as a judge, I've, had the issue of recusal come before. What's the basis for my recusal?
Obviously, it's
I mean, I'm not a commissioner. Whoever ends up being the next
understand,
commissioner
Judge.
doesn't matter anything to me. I'm a state employee.
Sure. Well, so the potential for conflict, I guess, could come into play because the judges are voting on the three choices, presumably at some point, that the Democrats have submitted. So a recusal in some way.
Yeah, and I should note that the only reason the judges haven't acted on that yet is because some of us had concerns that if we had proceeded forward and appointed someone pursuant to that process, and then an appellate court, whether the Commonwealth Court or the Supreme Court, said that the rule of judicial administration controls, we would then be in the position to essentially be yanking that person conceivably out of office if we interviewed a broader class of individuals and ended up selecting someone else. So you'd be putting someone in, taking someone out, putting it back in, and rather than have that chaos, and because, quite frankly, the two commissioners have seemed to be conducting their business well since, was it February or March that he resigned, we're waiting to get final word from the Supreme Court before we proceed forward.
Understood, Judge. Thank
Okay.
you.
Well, and then I'd just like to add too, and this is under the advisement of my solicitor, the Board of Elections really does not have the authorization to ask for a special election. That would have to come from the Board of Commissioners to the election board. And at that point, I don't disagree. The county commissioners really should not be on the Board of Elections when we're trying to fill a vacancy or have something to do with the commissioner office. So I think there is a conflict there as well.
Anything else? Okay, thank you.
Thank you, guys. Appreciate it.
Anyone else who wishes to address the board? Okay. So the record will reflect that no one else wished to address the board. Just to provide some background as to how we have gotten here this morning, shortly after I was appointed by President Judge Gibbons to serve as a member of the Board of Elections to fill the vacancy of former Commissioner McGloin, I forwarded a memo on April 10th, 2025, so a little bit more than 4.5 months ago, to Commissioner Gahn, Commissioner Shermack, and their solicitors, Mr. Frederickson and Mr. LaBelle, and understand that this was before the three judges, Judge Minora, Judge Mazzoni, and Judge Derulo, had even conducted their hearing on the issue that they had before them regarding the proper appointment process, whether it was the Home Rule Charter or the rule of judicial administration. So as of April 10th, I did not know how long I would be serving as a member of the Board of Elections. But I stated to the commissioners in that memo, which is 8 pages long and contains my analysis of the applicable law, that in the event I continued to serve as a member of the election board beyond the primary in April, quote, I wish to raise for your post-primary consideration the prospect of a special election to fill the existing county commissioner vacancy pursuant to section 1.2-206C of the Lackawanna Home Rule Charter 335 PA Code. The issue of a special election is independent of and distinguishable from the court appointment procedure question to be addressed by the 3-judge panel. They had not considered it yet. And the separate issue of a special election is governed by distinct legal authority and principles, close quote. And in my memo, I identified 4 laws that I believe are applicable to the issue at hand. The first is section 1.2-206 of the Home Rule Charter, which governs the filling of vacancies of any elected officer, which would include a county commissioner. Subparagraph A talks about when the office becomes vacant and identifies death, resignation, removal, inability to serve. Subparagraph B is the issue that's been litigated both before the 3-judge panel and the Commonwealth Court to date, and which is still pending on appeal before the Supreme Court, and that's the provision governing the vacancies in the executive committee of the political party of the person who vacated the office, submitting 3 persons to the judges of the court, and for the court then to appoint one of the 3 persons recommended, and the key language, in my opinion, is, quote, to temporarily fill the vacancy, close quote. And then subparagraph C is the paragraph that governs special elections, and it says a special election according to the laws of the Commonwealth of Pennsylvania shall be held at the next primary municipal or general election to permanently fill the vacancy. And then subparagraph D really doesn't apply, but that talks about if there's a vacancy that occurs during the last year of the office being temporarily filled, and of course that's not applicable here. Another governing law is section 2962 of the Home Rule and Optional Plan laws. That's the statewide statute, the Enabling Act, that permits counties like Lackawanna to adopt home rule charters. And subsection C2 of that statewide statute sets forth powers that are prohibited. In other words, powers that home rule charters cannot exercise or adopt. And it says that the home rule charters cannot exercise any powers contrary to powers granted by statutes, and this is the key language, quote, which are applicable in every part of this Commonwealth. So if we then turn to statutes that are applicable in every part of this Commonwealth, one of those statutes is the Election Code. And Section 602 of the Election Code states that when there are elections for county officials, of course this would include county commissioners, they're to be elected at the municipal election. And under the law, a municipal election is one that is conducted in an odd-numbered year, so 2025, for example, not an even-numbered year. That was one of the fatal flaws in the 2000 in-rate district attorney decision that Mr. Walker referenced, because the Board of Elections in that instance was attempting to declare a special election in 2000, which was an even number year, and not an odd number year, which would qualify for a municipal election. And then the last statute that comes into play, which does not apply in every part of the Commonwealth, is Section 12501, subparagraph B of the county code, which applies to second Class A through 8 class counties. So it does not apply to a first class county such as Philadelphia or a second class county such as Allegheny County. And that states, quote, "A vacancy in the office of county commissioners shall be filled for the balance of the unexpired term by the Court of Common Pleas of the county in which the vacancy occurs by the appointment of a registered elector of the county who was a member of the same political party as the vacating county commissioner at the time the vacating county commissioner was elected," close quote. So that indicates, arguably in conflict with the Home Rule Charter, that the person who's appointed by the judges will fill the balance of the unexpired term, which in this instance would be through December 31, 2027. I would note, because of the fact that it has been successfully argued on appeal to date, that the Home Rule Charter controls the appointment process, and the 3 names being submitted by the executive committee of the candidate who departed, that if Section 12501B were to be followed by the court and interpreted as preempting the Home Rule Charter, that doesn't state 3 names from the executive committee. It states the appointment of a registered elector of the county who's a member of the same political party. So again, the key aspect here, in my opinion, is that this is not a statute, namely the statute that says the court appoints someone for the balance of the unexpired term, is not a statute that applies in every part of the Commonwealth. So it is not something that the Home Rule Charter cannot have a contrary position on. Also, in the memo I sent on April 10th, 2025, there's 2 decisions I reference, one out of Lackawanna County, one out of Luzerne County, which I think are relevant. Some of you may recall that back in 2013, we had the government study commissions that were placed on the ballot. We also had the commissioners at that time were attempting to consolidate the row offices of clerk judicial records, register of wills, and recorder of deeds, and was also attempting to make the sheriff's office an appointed position. And one of the issues that were raised by one of the objectors in that case was that there was a publication requirement in the county code, Mr. Walker, that you referred to. There was a publication requirement in the county code that required one form of publication, and there was a separate provision in the Home Rule Charter with respect to the publication requirement. And he made the argument that although the commissioners at that time had complied with the Home Rule Charter publication requirement, they had not complied with the publication requirement in Section 509B of the county code. And Judge Mazzoni, Judge Giroulo, and I sat as a 3-judge panel considering all those objections, not only to the ordinance that the commissioners had passed to place that on the ballot, but there were other issues dealing with the Government Study Commission as well. And in our unanimous opinion, we noted that Section 509 of the County Code may prevail over Section 1.3-311 of the County Home Rule Charter only if the County Code is uniformly applicable in every part of this Commonwealth. And that since the County Code does not apply to every county in Pennsylvania, the ordinance publication requirements set forth in the County Code did not preempt the ordinance publication requirements contained in the County Home Rule Charter. That issue was appealed to the Commonwealth Court of Pennsylvania, and on April 15th, 2013, they issued an opinion. I quoted from it at length in my memo that I had sent to the commissioners, but a few provisions that I would note for purposes of today, because it is a ruling of the Commonwealth Court. They noted that, quote, as a home rule county, Lackawanna County is not subject to the requirements of the county code, close quote. They also referenced the Enabling Act that I mentioned earlier, where we cannot have a home rule charter provision that is in conflict with the statute that applies in every part of the Commonwealth. And they stated that that limitation, quote, which bars the exercise of a power contrary to statutes of statewide application. The commissioners were only obligated to enact the ordinance in procedural conformity with the Home Rule Charter and any requirements applicable in every part of the Commonwealth. The county code does not have statewide application and therefore is not applicable to passage of Ordinance 224, close quote. One of the issues that had been raised, not unlike you, Mr. Walker, was the application of the in re district attorney opinion from 2000. And the Commonwealth Court continued, hence the question before us concerning the applicability of the county code's pre-enactment publication requirement requires either reconciliation with in re district attorney or a rejection of its holding regarding the county code, period. We do the latter, period. So they then upheld the ruling that had been made by Judge Mazzoni and Judge Cerullo and I, and held that the conflicting provision in the Home Rule Charter regarding the publication requirement was not preempted by the county code. My memo also mentioned there was a 2021 decision by the Commonwealth Court of Pennsylvania dealing with the appointment of the district attorney there, because what had happened is the sitting district attorney resigned in order to run for judge in that county, and District Attorney Sangladucci was appointed on March 25th, 2021 to serve the remainder of the term through December 31st, 2023. The Luzerne County Board of Elections declared a special election in November 2021 pursuant to a Home Rule Charter provision. And the district attorney argued that the Board of Elections could not do so under the county code because no primary election had been conducted. Luzerne County judges actually recused on the issue because they had made the appointment. A visiting judge was brought in to decide the issue, and he decided the issue in favor of a special election. That was appealed to the Commonwealth Court, and the Commonwealth Court agreed and held that the election code allows for a special election to be conducted without a primary, and that the Luzerne County Home Rule Charter authorized a special election in November of 2021. So the special election was conducted. So after discussing all that case law, I concluded my memo of April 10, 2025 by stating, quote, by the time that I was appointed to the Board of Elections on March 24, 2025, the deadline for the filing of primary nomination petitions on March 11, 2025 had already expired, and I therefore saw no need for the Board of Elections to address the prospect of a special election in advance of the primary election on May 20, 2025, period. But since the Luzerne County Council decision in 2021 confirmed that a special election may be conducted during a municipal general election without the necessity of a municipal primary election, I respectfully submit that a special election on November 4, 2025 for the currently existing county commissioner vacancy should be considered and decided by the Board of Elections after the May primary election, close quote. And that's what I had forwarded to the commissioners at that time. We actually had a speaker at our June 6, 2025 meeting who she indicated that she intended to file a lawsuit in order to have a special election declared. So I had thought personally that that issue would be raised sometime in June or July. But as we approached the September 5, 2005 deadline for the filing of a special election, I forwarded another memo to the commissioners on August 20th, 2025, where I stated, quote, "In light of the 60-day deadline set forth in Section 628.1 of the Election Code, 25 PS Section 2778.1, requiring the election board to issue the writ for such a special election by no later than September 5, 2025, I am renewing my request that you and your solicitors examine and consider the prospect of a special election to fill the vacancy in the office of County Commissioner." My memo briefly referenced that same law that I have already mentioned to you all, but I also made reference to the July 18, 2025 opinion of the Commonwealth Court in the case that's been referenced here, in re appointment to fill a vacancy in the office of County Commissioner. And specifically, in the Westlaw copy, at *9 of that opinion, the Commonwealth Court unanimously held that, quote, "By enacting the Home Rule Charter, Lackawanna County became a Home Rule Charter municipality governed by the Home Rule Charter and removed from the operation of the county code, which applies in the Commonwealth's non-Home Rule counties," close quote. So I think that's a continuing definitive message from the Commonwealth Court that if there's a provision in our Home Rule Charter and there's a contrary provision in the county code, the Home Rule Charter would prevail. And in this instance, the provision in the Home Rule Charter calls for a special election, and the provision in the county code calls for the judges to appoint someone for the balance of the unexpired term. And they concluded the opinion by referencing, I mentioned, paragraphs A, B, C, and D of the Home Rule Charter, and they stated Section 1-2.206 of the Home Rule Charter provides conditions upon which a vacancy occurs, and that's what I mentioned earlier, the death, resignation, or inability to serve. Instructions for the selection of prospective replacement candidates in Lackawanna County when such a vacancy occurs, and for the forwarding of such candidates to the trial court, and that's subparagraph B, which has been litigated in the courts in 2025, and the procedures to be employed to permanently fill the vacancy once the trial court fills the vacancy, and there's the reference to subsection C and subsection D. So after I sent that memo on August 20th, I did receive an email from Commissioner Gahn indicating that he wished to have us conduct this meeting here today in order to address the issue of a special election. So with that kind of long-winded background, but letting you know, this is not something that has just become a topic of consideration among the election board this week or within the past couple of weeks, but this is, this was an issue that was really brought up more than 4.5 months ago, and just needed to be resolved and needed to be addressed prior to September 5th, 2025. So with that background.
So can I ask a question? Sure. So, so under the county code that we function with here in Lackawanna County, we operate on a two-party system, majority and minority. So if the roles were reversed, and right now we were looking to have a special election, and it was going to be to replace me as a minority commissioner, that means that now there's an opportunity to have 3 Democrat commissioners sitting here, which I think goes against our system and the two-party system that's in place. So I still think that, even though this case, it's one of the majority commissioners, and again, nothing would make me happier to see a Republican win this special election, and then the things would change. But that doesn't make it right. So that's my concern. I mean, and this is me. I'm a car salesman. I'm talking to a judge. So just keep that in mind. But so that's my question.
You can sell your case better than I can.
Yeah, maybe. Right? But that's my concern. because it is a two-party system, majority, minority, in the future, this could have ramifications that would not be, too many people wouldn't be too happy with. But the second part of this whole thing, and this is what I said from the beginning, I feel the Board of Elections is not authorized to call a special election. It has to come from the Board of Commissioners.
Thank you. Commissioner Gawin? Oh, okay. So were you addressing that to the solicitors? Or just making comments?
I'm making comments.
Okay.
I'm trying to make my point on how I feel. Again, if this was in the home rule charter and part of what our normal operations would be is to hold a special election and things that we've done in the past, I wouldn't have an issue. But my concern is not necessarily for this exact special election, it's for something that could happen in the future. And this would set a precedent that there's going to be a special election, therefore there could be 3 Republicans sitting here or 3 Democrats sitting here, which goes against our charter and the two-party system.
It's not without precedent, it's happened before. We had 3 Democrats.
Voted in as 3, or did they switch their party
The one
during?
switched the party, but we did have three Democrats at one time. Commissioner Stayback,
But
Juan, Zach, and
that
O'Malley,
doesn't
so.
set the precedent for voting for
I'm
who
just
the
saying, we've
public
had
wants.
3, we've had 3
Well, that's-
Democrat commissioners. in the
That's
past.
because they changed their party, which is, to me, if they change their party, it's still a two-party system, majority, minority. If they change their party, they shouldn't be allowed to serve. That's my opinion.
Thank you, Chris. Commissioner? Well, let me direct it to the solicitors. In response to the argument or statement that has been made that a special election can only be declared by the Board of Commissioners as opposed to the Board of Elections, and I have to confess, in reading the case law, they would refer to the Board of Elections having declared or the Board of Elections having declared special elections, but I don't know if that was in response to a directive from the commissioners or whether they had done that independently or how that came about.
Actually, you know what, I will comment now.
Okay.
So I want to thank, oh, is this on?
No. Do I have to turn off?
No. I'm looking at it. Or is there one up there I can use?
Somebody's trying to send you a less than subtle message.
Push the button.
Hello? Push the button.
They're not working.
Nope, not working. Thank you. Thanks, everybody. I want to thank Judge Nealon for that thorough analysis. I will be voting yes for a special election to fill vacancies in the Office of Commissioner and the Clerk of Courts. This decision is an easy one for me. Since March, I have been fighting in court for transparency because the next county commissioner should not be the product, in my opinion, of a closed-door process shrouded in secrecy and mystery. We must act now for a special election to make sure that the races are on the general election ballot this November. Nothing is more important than allowing the voters of this county the opportunity to elect the next commissioner and clerk of judicial records instead of leaving those important decisions in the hands of a few behind closed doors in smoke-filled back rooms. I'm happy to help make that happen in this case, and I look forward to working with the next commissioner and clerk of judicial records chosen by the people of Lackawanna County. Thank you.
Just for the record, the 8 judges will be meeting in the courthouse and no smoking is allowed there?
No, I wasn't
So
talking about the judges.
And I just, I do have an extra note here about the Board of Elections, what they're authorized and what their duties are. Under 25 PS Section 2642 lists the powers and duties of the Boards of Election, which I don't have in front of me, but that's where that could be found.
Okay, thank you. I had posed to the solicitors the issue as to whether the Board of Elections is authorized to declare a special election, or may only do so pursuant to a directive from the Board of Commissioners?
Well, that's a very good question, Your Honor. As you have indicated in the case law, the Board of Elections has in the past, in other counties, declared an election, or a writ of election. So we believe that we're covered by that. So,
Does anyone have the provision with them that Commissioner Schermack was citing?
I do, sorry, I do, Your Honor, if you would like to see that provision, bear with me. And I would respectfully disagree with Attorney Frederickson. Nowhere in that section does it authorize the Board of Elections to order a special election. If you read In Re District Attorney, the 2000 case, which Your Honor has referred to, there's language in there that says that the issue was brought when the Lackawanna County Commissioners sent a request to the election board to schedule a special election. I believe the election board has the power to schedule a special election and administer over elections, but in the limited time I had to do research, I was unable to find a case that said the election board of any county could initiate a special election. I personally believe it's beyond the powers of the election board to do so. My research shows that the governing body for any municipality in the Commonwealth of Pennsylvania provides a request, usually to the Bureau of Elections, saying that a vacancy has been created that would require a special election. The formal way to do that is through a writ of election. An informal way is to send a letter, is to send an email, but the request has to come from the governing body of the municipality. And in this case, the governing body of the municipality would be the county commissioners.
Yeah, and, well, I'm just looking at what you passed up, which is Section 2642, Powers and Duties of County Boards, and there are subparagraphs A through P, and not one of these subparagraph states that upon the directive of the county commissioners or upon the directive of the legislative body to declare a special election. So if we're to consider this as being, a statute of limitation, meaning limiting powers, how could any election board ever declare a special election in the Commonwealth of Pennsylvania? Because it doesn't say anywhere in here that they can do so upon the directive or vote of the county commissioners.
I understand. Go ahead, Donnie.
Your Honor, two things I would just point out is, as you had indicated before.
And to me, I interpret this as meaning we either have the authority irrespective of whether the county commissioners direct it or not, or we don't have the authority even if the county commissioners direct it. And I would think that if it was the latter, we wouldn't have all this case law.
Additionally, Your Honor, I would just point out, as you had indicated before, there is some case law out there that indicates that the Board of Elections in the past have issued writs of election. But additionally, I would just point out that our Home Rule Charter itself mandates that there be a special election in the event of a vacancy in an elected office. So I think it's mandated by the Charter, and I think that there is some case law out there that
And again, Your Honor, that mandate would presume that according to the law that I have reviewed, that request come from the governing body of the municipality.
Let me ask you a question, though, just as a practical matter. When I send my memo to the commissioners on April 10th, more than 4.5 months ago, and say, my reading of the law indicates we should consider, I didn't say we should do it, but we should consider a special election. I copied you and I copied Mr. Frederickson. Why don't you write back and say, oh, don't bother. Judge, because the Board of Elections doesn't have the authority to declare a special election.
Well, with, again.
Or even when I sent the memo, the second memo on August 20th saying we've got a deadline approaching us.
Again, Your Honor, you asked us to consider it, and you said that it could be a possibility. And I agree, it could be a possibility, but I believe it would have to follow proper procedure. And you've been a judge for a long time, and you're an excellent judge. You write wonderful opinions.
Flattery will get you everywhere.
No, I'm not.
Go ahead.
I'm not just blowing smoke. I respect you as a jurist 1,000%. I believe that your memo put forth the proposition that could be a possibility, but I believe it couldn't become an eventuality until the governing body, i.e. the county commissioners, declared the seat to be vacant. And I would posit to you that if South Abington Township, for example, wanted to operate without a 2-year auditor and a 4-year auditor, I don't believe that the Board of Elections could mandate a special election to fill a seat that South Abington Township supervisors didn't believe needed to be filled.
Yeah, the chief of staff indicated they don't operate under the home rule charter. South Abington Township.
I understand that, Judge. The point that I'm trying to make is that I believe, now that we're here today before the election board, that the governing body for any municipality, in this case, i.e. the county commissioners, need to request or point out to the election board that there needs to be a special election. I do not believe the election board has on its own authority, and that list that's contained in 2642, I don't believe anywhere in those 16 powers and duties that are listed, it says to initiate a special election.
Nor does it say to declare a special election in response to a directive from the county commissioners or the legislative
I agree.
body.
I agree with that.
It doesn't say anything on special.
I agree with that wholeheartedly, Your Honor. It does not even address the issue of how a special election.
And I would think that if an election board did not have the authority to declare a special election, even at the direction of the county commissioners or whatever the legislative body would be, the minute any special election issue went up on appeal in response to a special election being declared by the Board of Elections, whether it was the 2021 Luzerne County case, whether it was the 2000 Lackawanna County case or any other case, the court would have been able to deny it with one line saying the power to declare a special election is not itemized in Section 2642, so the Board of Elections had no ability to do so.
I respect your point, Judge, but in the In-Ray District Attorney 2000 case that we've been referring to here, the county commissioners did request a special election.
Well, the county commissioners were sitting as the Board of Elections that year in 2000. They were not on the ballot.
I assume you're correct. I don't know that as
I mean, the
a
only
fact.
time the county commissioners don't sit as the Board of Elections are the years that you're on the ballot, correct?
Correct.
Yeah.
But I don't believe that request came as they sat as the Board of Elections. I believe that request, and I don't know this for a fact, came from the county commissioners sitting as county commissioners.
Okay. I mean, I don't know that that is or isn't.
And Your Honor, I believe we're going to face the same issue with regard to replacing Maury Kelly, because, again, to me, it would be the governing body, either Lackawanna County court system or the Board of Commissioners, that would declare the seat vacant and therefore create the need for a special election. And I think in her case, it's even a little bit more tenuous because
That's a question, and we're not there yet, but that's a
Okay.
question I have for the solicitors as to whether a special election can be declared for the clerk of judicial records vacancy, because although we know that we'll be losing our Maury as of September 2nd, 2025, as we sit here today, no vacancy officially exists.
and that, again, if anybody cared about my opinion, that would
We all care about your opinion.
that would be my opinion. There is no vacancy that's been created, nor, as in the case of Matt McGloin's resignation, has anybody accepted her resignation.
His.
I believe, and I don't know that for
Well,
a
no,
fact. Maybe the court did.
there was an order issued by Judge Corbett accepting Matt McGloin's resignation.
Correct, but that
He's talking about Maury Kelly.
came later. I don't believe,
Oh, yeah, I thought you said as in the case of Commissioner McGloin.
right,
No,
but I
Commissioner
think,
McGloin's resignation
Oh, I
was
see. Okay,
was
all right.
accepted by the
Yep.
Board of Commissioners also on March.
All right, I misunderstood.
but it was never accepted by the Board of Commissioners. It was accepted by then President Judge Corbett. In Maury Kelly's case, I'm not aware that anybody has accepted her resignation, so the possibility, although I know she won't do it, she could withdraw her resignation and please everyone and come back to serve the county, but that opportunity still exists. So again, I don't believe that issue's ripe for a special election, Your Honor.
Okay. Well, but, and again, I don't see anything in the Home Rule Charter stating that the special election is to be declared by the commissioners.
I don't believe that there is, and it could just be precedent that has been in existence for years that the governing body submits the request. I can't answer that.
Your Honor, I would just point out again, the wording of the charter itself is clear in that it mandates that there be a special election when there's a vacancy in an office or
Well,
position
why did you
in the
tell us
county. So-
months ago that we couldn't have a special election?
Because we was looking at the In re DA case, but it has such come to light that the In re DA case has been overruled by subsequent Commonwealth cases. So.
I mean, the In re DA's case, just so that you understand,
Yes.
there were two issues that the majority opinion relied upon. One was that the county code in existence at that time stated that and I was one of the judges who appointed District Attorney Jarbola at the time, so I was intimately involved with it. But the county code at the time said that the person who we appointed would serve for the balance of the unexpired term, which would have been through December 31st, 2001, which was the remainder of then District Attorney Barace's term. And then the Home Rule Charter provision, at least the commissioners and the Board of Elections' interpretation of it at the time, was that it called for a special election. And the Commonwealth Court majority opinion relied on 2 points in determining that a special election was not warranted. One was the election code provision that I referenced earlier that said that municipal, county commissioners, county officers will be elected at municipal elections, which are odd number years, and they were trying to do it in the 2000 even number year. The second was the county code provision, which they said had preempted the Home Rule Charter provision. There was a dissenting opinion by Judge Pellegrini in that case, and then in a series of follow-up decisions that the Commonwealth Court then issued over the next several years and even up through the present, they agreed with that aspect of Judge Pellegrini's reasoning, which was the county code can't preempt the Home Rule Charter because it isn't applicable in every part of the Commonwealth. So if you ever shepherdize, for those of us who are old enough like Howard Rothenberg to know what the word shepherdize means, but if you ever shepherdize the in-rate district attorney decision, a red flag comes up for that part of it was abrogated. So the conflict between the Home Rule Charter and any county code, the county code no longer prevails, but of course the election code would, because that applies throughout the Commonwealth.
Your Honor, if I may.
Yeah.
With all due respect to Attorney Frederickson, if we're following the Home Rule Charter, then we have skipped step B that's clearly set forth that says the judges of the Court of Common Pleas needs to fill the vacancy. The vacancy has not been filled, so again, I think it's premature to move to a special election, regardless of whether a special election should be held, could be held. Without the filling of the vacancy, I don't believe we can just skip Section B and move right to Section C.
Yeah,
And
I
I
mean,
think
B, as
Attorney
you said,
Walker
I'm
brought
sorry.
that up.
Yeah, as you said, B talks about the court appointing one of the three people to temporarily fill the vacancy, and C talks about a special election to permanently fill the vacancy. And perhaps the drafters of the Home Rule Charter at the time had the thought process of a more
Orderly.
orderly transition there. But I'm looking at C, and I would agree with you if it said, once the judges have temporarily filled the vacancy, or after the judges have temporarily filled the vacancy, a special election shall be declared at the next.
I
primary.
understand.
I Judge, in reading Section B of the Home Rule Charter, that particular provision, it indicates that, right, that the judges shall temporarily fill the vacancy, but it does not, to me, it doesn't preclude us from moving to subdivision C and the special election. They don't seem to be incumbent upon each other. In
Your
other
Honor,
words, one has to affect the other.
That may be the case, but in fact, Section B is what Commissioner Gahn has been litigating on, the procedure to fill that vacancy. So I don't see, again, how we can call a special election when the procedure to fill that vacancy hasn't been finally determined.
Yeah, I would just argue on that, Your Honor. They're two completely different tracks. The appeal before the Supreme Court right now deals with who has the authority to make that temporary vacancy, where subsection C calls for it mandates a special election when there is a vacancy. But to me, they're uncorrelated and unrelated to each other.
And that's also correct. However, the Commonwealth Court did decide that the judges of the Court of Common Pleas should fill that vacancy based on a list of 3 people provided to them by the Democrat Party of Lackawanna County. If what Attorney Frederickson is saying is true, then the judges of the Court of Common Pleas of Lackawanna County could act today to fill that seat. If they did that and the election board scheduled a special election, then the outcome that Commissioner Chermak talked about could be that we would have a judge appointed potentially for the a commissioner appointed potentially for the remainder of former Commissioner McGloin's term, and a new commissioner elected at a special election in November. And then, as Commissioner Chermak pointed out, we could have 4 commissioners. We go from 2 to 4, but we really want to
They
go from
would
2
sit
to 3.
at the same time, because the person who's elected in November would not take office until the first Monday in January.
No, they would take once the certification of the election.
Oh, is it? Okay, I stand corrected.
Certification of the election.
Yeah, well, I think once that person's elected, the
temporary
person
one
who's
would go
appointed
away. Would go
to,
away, yes.
quote, temporarily, close quote.
Additionally, I would just point out, Your Honor, subsection C calling for the special election, as the Commonwealth Court in the Home Rule Charter case indicated, was not applicable because of the fact the third-class county code is not applicable to every county or across the Commonwealth of Pennsylvania. However, the argument regarding the appointment of filling the vacancy under subsection B, the argument is whether or not Administrative Rule 1908 is applicable across the Commonwealth or not, and there's a difference there between the two.
Yeah, and I, without oversimplifying it, the way I read the Commonwealth Court opinion is they felt as though the Home Rule Charter and the Rule of Judicial Administration could be applied in harmony with one another.
Well, additionally, I would just...
I know you may disagree with it, and I'm not saying
No.
you're right or wrong. I'm not commenting at all on it. I'm just
I
saying what they
understand, Your
said.
Honor. I would just point out additionally, in its decision, the Commonwealth Court, in the appointment to fill the vacancy of a commissioner, in their opinion, actually references Section C of our Home Rule Charter, indicating that they're in conformity with Section C. And that's in the decision from the Commonwealth Court in re the appointment. The procedure is to be employed and permanently fill the vacancy once the trial court fills the vacancy.
All right. Go ahead, any other comments you wish to make? And I appreciate Solicitor LaBelle providing me with a copy of Section 2642 of Title 25, because the one note I had made to myself was whether, after Commissioner Shermack had read his statement, whether the Board of Elections could declare a special election absent a directive from the county commissioners to do so, and I was looking for some language in that statute that may state that, but as I mentioned earlier, it's completely silent on special elections, so I don't think it states that we have to wait for the county commissioners to issue a directive. I think, we either have the authority to do it or we don't, and I would think that if we did not, that would have been decided on appeal a long time ago, after all these Board of Elections, special elections were declared. So, but go ahead, were you?
No.
Did you make a motion?
No, I believe you have to read the motion.
Oh, okay, I'm sorry. Anything else from you, Chris? Okay. So the first motion that we have before us is the motion to declare a special election to fill the vacancy in the office of County Commissioner on the Lackawanna County Board of Commissioners pursuant to Section 1-2.206, close paren, of the Lackawanna Home Rule Charter to appear on the ballot for the November 4, 2025 municipal general election, close quote. Yes. Okay, I'm sorry, motion 25-2009. Do you want me to read the motion again, or is that satisfied, Mr. Jeffers? Okay.
So moved.
Any second from the Commissioner Sherback? Okay, I will second that motion with due respect to all the arguments that have been made here today. We're up against a time deadline for declaring a special election, and I don't see anything in the statute that has been provided that states that we have to wait for directive from the county commissioners. And I think that the way subparagraph C of the Home Rule Charter reads, that it reflects an intent to have the vacancy permanently filled by the more than 145,000 registered voters in Lackawanna County rather than the 8 commissioned judges. So I will second that motion and call it for a vote. All those in favor signify by saying aye. Aye. Opposed?
I'm going to abstain. There's just too many questions in my head at this point. I had an answer, but after today's discussion,
Can you abstain?
I can
He
abstain.
can abstain. He needs to state a reason why he's abstaining, that's all.
There's just too many questions in my head right now. Again, I'm concerned about moving forward for another special election, in this case, where we could end up with 3 of the same party here.
That's,
I don't think this is the right thing, and I have to vote from what my heart and what I think is correct and what is right for me. And right now, there's way too many questions in my head. I've heard a lot of great arguments. I'm not sold on first of all, that we have the authority, and I'm not sold on that this is the correct thing to do, especially moving forward.
And again, I would note, I wish these questions had been raised sometime during the past 4.5 months, that everyone had been in possession of my memo suggesting that we consider it. But anything, okay, then the second motion that we have is motion 25-2010, motion to declare a special election to fill the vacancy in the Office of Clerk Judicial Records pursuant to Section 1-2.206C of the Lackawanna County Home Rule Charter to appear on the ballot for the November 4, 2025 municipal general election, close quote. And I indicated earlier, a question I have is whether we can do so now before the vacancy actually exists, or whether we need to have another special meeting next week after Maury Kelly resigns on September 2nd.
Thank you, Your Honor. First of all, answering the question with regard to accepting Maury Kelly's resignation, I'm not sure who would accept her resignation, because the Board of Commissioners clearly can't accept it. She doesn't work for them. She's an independently elected official of the county. Normally, her resignation would take effect on the 2nd, the date she gave notice for. She would have to submit it to, I guess, our HR department, so they can take her off of, the schedule, off the seniority list.
Why would her resignation not be accepted by President Judge Gibbons, just as Commissioner McGloin's had been accepted by President Judge Corbett?
I can't answer that one, Judge. I don't know. I don't know. Yeah. I don't know who would. I guess the court could accept her resignation but she is an independently elected row officer, so she reports to herself. Really.
What's your position as to how it's officially accepted?
Your Honor, my position. Thanks, Beth. My position is that either after September 2nd.
Go ahead.
Either after September 2nd, after Maury Kelly is no longer serving in her capacity, or I would believe that, as you said, the president judge would need to accept her resignation to create the finality that she may not reconsider and return to her position. So I think any special election being declared for that office today would be premature. As much as I'd like to wrap up the election board dealings today, I think we would.
I think you'd have to stand behind me in that line.
Yeah, Judge, because Maury Kelly, of course, is the clerk of judicial records and handles the records of the courts and the docketings over there. But if, let's say it was the county treasurer who was to resign, who would accept their resignation? Evidently, they're not a officer of the court, and they don't really work for the commissioners.
But nor was Commissioner McGloin. And
well, he was on the Board of Commissioners, so the Board of Commissioners needed to accept his resignation. There's actually law on that.
Which they didn't do until sometime after.
March 5th, yeah.
Right, and still, I believe, until sometime after Judge Corbett had accepted.
She did it first?
I'm not sure when she did, but I know the board did.
I believe she did it
accept
first,
yeah.
so that they could begin the process of selecting someone to fill that vacancy, but then it didn't become official till the Board of Commissioners accepted it. And I understand that all of the row offices are unique, but I don't think, out of an abundance of caution, belts and suspenders, we need to wait until Maury no longer shows up for work to declare her seat vacant.
Yeah, and in order to address that, is what I had proposed was we add to the motion a caveat that the writ of election not be issued until September the 3rd, which would be the day after her resignation takes effect.
Does that work for you?
I don't have a dog in that fight, Judge. If the election board and Your Honor believe that's the way to go, then so be it.
Yeah.
I think we have two options.
Let me ask you this: who's our parliamentarian here in terms of making a?
I can make I think a friendly amendment to the motion, correct, Don?
Yeah.
Well, that motion hasn't even been read yet.
Yeah.
So.
Right, if you want to,
I was going to make a separate motion.
oh, that's good, yeah. We could do that.
But, I would make a motion that we not consider motion 25-2010 until our next special meeting to be scheduled sometime next week before September 5th, but on or after Maury Kelly's resignation on September 2nd.
Your Honor, in the interest of election board, the timeline and everything, I believe, and I would defer to Donnie, but I think we can continue this meeting to another date, and then we wouldn't
We could just
require.
adjourn and reconvene.
Then we wouldn't require a new notice to be posted in the newspaper, which is going to be difficult time-wise because of the Labor Day weekend.
Does anyone have their calendars?
Calendar?
The first is Monday.
Tuesday's the second, you can have it on the third.
Third or the fourth, yeah.
I mean, to have it at noon is always safe, because even if we have court business
She would be officially resigning at 4 o'clock.
on Tuesday, September 2nd?
She would be officially resigned at 4 o'clock on Tuesday, September 2nd. Therefore, you can have it the following morning.
Okay.
If you so choose to.
We have a Board of Commissioner
I
meeting.
know,
Yeah,
10 o'clock.
okay.
I think you can do it
Okay.
10:30.
We don't have to have our meeting before your Board of Commissioners meeting, do we?
No.
No.
Okay, so if your Board of Commissioners meeting is at 10 o'clock,
We're at 10 o'clock.
and would you be free at, say, okay?
Yes.
Does that work for you?
Yes.
All right, so how about we'll adjourn the meeting, PJ, and resume on Wednesday, September 3rd, 2025 at 12 p.m. in order to consider motion 25-2010.
We would continue the meeting, not adjourn the meeting.
Oh,
Yeah,
I'm
yeah,
sorry,
that's all right.
continue
No
the
problem,
meeting.
Your
All
Honor.
right, all right.
Let's make a motion to continue the meeting.
Okay, see, we adjourn court
Does
every
that-
Yes,
time we
yes.
break for.
Does that
for like-
affect at all the first motion that was made
No.
and passed?
No, that's already been voted upon, Commissioner.
Okay, so that gives Beth Hopkins the ability to start moving the
Yes.
forward on the special election.
Okay, so we'll continue the meeting until Wednesday at noon to consider 25-2010, correct?
But I think-
Do I need to make a motion?
I think we still need to do opportunity
Yeah.
for the public to address
Right.
the board and then members of other
You're
business.
on-
And then I think you can,
Oh, I'm sorry, yeah, but I didn't move to adjourn our meeting.
Oh, okay,
I
I'm
meant to
sorry, I thought you
continue,
did. Okay.
yes.
We're going to continue the meeting. Yeah, before you do that, we need to read into the record the vote on the first motion, which, 2-1, yeah. So it's two in favor.
Favor
0, and then an
and
adjourn-
one
an
abstain.
one abstention.
Yes, correct. Okay, all right. All right, then, next we have the opportunity for the public to address the board on any matters, not only agenda items.
Joan Hodawan, Scranton. Well, I guess I'm the only member of the public here, but I think we need to end this thing on a positive note. And all I want to know is, do lawyers and judges get paid by the word? I have such a headache.
No, but we should.
I'll be, I'll be looking for what happened at this meeting when I read it in the Times Tribune, because I am so lost. Thank you.
I was going to say, that'll be only one, everyone's only takeaway. Anyone else who wishes the opportunity to publicly address the board? Okay. All right, any other business that needs to be considered?
no, just final comment on this. I am happy that we're moving forward with the special election. I do find it amusing that there seems to be harmony between the Democratic Party and Republican Party on shutting the people out of the process, which I think is outrageous. But I'm happy that this now is going to be in the hands of the people, and it will be done in a transparent way. Thank you.
Okay, and
If I may, I just can't leave that hanging out there. I don't represent the Republican Party of Lackawanna County. I represent Commissioner Chris Shermack. So any parallels that you wish to draw between the Democrat Party of Lackawanna County and the Republican Party of Lackawanna County, unfortunately, I believe are misplaced at this point.
And so we won't be adjourning, oh, I'm sorry, were you finished? I didn't.
No.
Okay. We won't be adjourning as indicated on the agenda. We will be continuing the meeting until Wednesday at noon. Okay? Thank you. Thank you, everyone.